All right, y'all, coming at you with chapter 3. This is medical, legal, and ethical issues. All right. We're going to go over scope of practice, issues of consent and refusal, legal aspects of emergency care, what negligence is, what an intentional tort is, confidentiality, HIPAA, EMTALA, and how to protect yourself. All right, EMTs Phil, Baker, and Caitlin have responded to an alley behind a strip mall for an unresponsive person. Police are on the scene and are conversing with a patient who is now sitting up. The patient, who is disheveled and smells of alcohol and urine, shouts, "I'm not going to the hospital. Get out of here." All right, what are some of your legal obligations in this situation? Do you have a duty to act? All right. Can you just turn around and leave the guy alone? All right. What are some of the ethical obligations do you have with this patient? And what information should you attempt to obtain from this guy? All right. Every EMS call involves legal and ethical decision making. Although most instances are clear, some are not so clear. Okay. All right. In some cases, an EMT must weigh complex information to act in the patient's best interest. All right. You will often act on medical, legal, and ethical issues such as these during your career as an EMT. You are likely to be sued successfully if they provide and careful document emergency care within your scope of practice and local protocols and knowledge of issues such as patient consent and duty to act. All right. Your legal duties. What is the scope of practice and what is the standard of care? Typically, state laws identify the EMT scope of practice or the actions and care that EMTs are legally allowed to perform by the state in which they are providing emergency medical care. The scope of practice asks, was the EMT allowed by law to do what they did? Scope of practice also identifies which activities would be deemed illegal if performed without licensure or certification and establishes boundaries among professionals. You as an EMT cannot intubate somebody. You cannot start an IV on somebody. You can, however, apply oxygen. You can give aspirin. You can give nitro. And you can transport. Okay? Legal duties. Pre-hospital emergency care has changed significantly since its early days. One improvement has been in the quality of training that emergency medical personnel receive today. The public and healthcare profession have come to expect a competent EMT who understands and accepts the legal and ethical responsibilities to patients, to the medical director, and also to the public. Okay? All right. How are scope of practice and standard of care different? All right. We're going to go over this. All right. 2 principles for standard of care. Did you provide the right assessment and care? And did you perform the assessment and care properly? Okay. State law identifies the level of care that you can provide. You may not perform care that is outside of your scope of practice. There is a difference between an EMT's scope of knowledge and a scope of practice. All right. You cannot perform skills outside of your legal scope of practice, even if they know how to perform the skill. Okay. The standard of care defines what is considered competent care by an EMT in any given situation. All right, your legal duties. You have a duty to act. The concept known as duty to act refers to your legal obligation to provide service whether you think the patient needs an ambulance or not. Legally, while you are on duty, you are obligated to care for a patient who requires and consents to it, rendering the necessary emergency care to the best of your ability and training. If you are off duty, not functioning in an EMS capacity, however, in most states, you have no legal obligation to act than any other citizen. While you're off duty in these states, you could legally do any of the following. You could stop at the scene of an accident and help the victims. All right. You could pass the scene and call for help, or you can pass the scene altogether and make no attempt to call for help. Okay. All right. One of the most important aspects of duty to your patient involves respecting the rights of the patient. Part of that protection includes maintaining the privacy and confidentiality of the patient's medical status, history, and records. Not only does the EMT provide care for the physical injuries and illnesses, but also meeting the emotional needs of the patient. You must also do no further harm. Your duty goes beyond accepting the responsibility to respond and providing emergency care to a patient. You also have a duty to yourself, a duty to your partner, and a duty to take responsibility for your equipment. All right, Good Samaritan Law. The first Good Samaritan Law was enacted in 1959 in California, specifically to protect from liability persons licensed, such as a physician or surgeon, who in good faith rendered emergency care at the scene of an emergency, for civil damages as a result of any act or omission. Many states have immunity laws of their own, some of which specifically cover pre-hospital care providers. Generally, a Good Samaritan law protects a person who isn't being paid for their services from liability for acts performed in good faith unless those acts constitute gross negligence. Therefore, the person suing must prove that the care provided was markedly below the standard of care and in some cases with willful or wanton intent to harm the patient. Okay? All right, you must render care to the best of your ability. Act professionally. Work within your scope of practice. All right, sovereign immunity is afforded in some cases to government employees. Statute of limitation restricts the amount of time a person has to file a lawsuit, and contributory negligence on the part of the patient. Okay, all of these can vary from state to state. EMTs may practice only under the direction of a physician, medical director, according to standard order, protocol, or direct communication. Your legal right to function as an EMT is contingent on medical direction. When providing emergency care, you should follow standing orders or protocols as approved by the medical director. Establish cell phone, telephone, or radio communications with the medical director when appropriate. Communicate clearly and completely with the medical director and follow orders that they give you, okay? And anytime there's a question about the scope or direction of care, you need to consult your medical direction. Ethics is a branch of philosophy specifically directed towards the study of morality or morals. Morals are concepts of right and wrong. A code of ethics is a list of rules of ideal conduct. A code of ethics for EMTs was issued by the National Association of Emergency Medical Technicians in 1978. Basically, if you place the welfare of the patient above all else when providing medical care, you will rarely commit an unethical act. All right, so EMT code of ethics, all right, serves the need of the patient. Maintain skills mastery. Remain abreast of any changes in EMS. Critically review performances. Report with honesty. Work harmoniously with healthcare providers. All right, the EMTs approach the patient. Hi, says Caitlin. My name is Caitlin, and I'm an EMT. We're here because someone called to say you were unconscious. How are you feeling? The patient responds, like I've got too many people not minding their business. That's how I feel. Why don't you all just go away and leave me alone? Should Caitlin and Phil do as the patient has requested and leave him alone? What is the legal basis for your answer? Do you have a legal basis for your answer? Do you think your answer is going to stand up in court? Okay. If you believe Caitlin and Phil should stay, what do you think they should do next? All right. Legal issues in the EMS include those involving patient consent, advance directives, and refusal of care. Competent patients have the right to accept or refuse emergency care. You must obtain consent or have a legal right to do so before providing care. You have different types of consent. You have informed consent, expressed consent, implied consent, minor consent, and involuntary consent. Okay? The patient has the right to decide for themselves whether or not to receive health care, but they must be advised of and be able to understand the proposed treatment, as well as the risk, options, and consequences for not accepting that care. Patients who are under legal age or otherwise not competent to decide for themselves What's best must have someone else consent for them. Okay? You may sometimes be called to treat terminally ill patients. In some cases, the patient may request and a physician may order that no resuscitation measures take place if the heart or lungs fail or stop functioning. Legally, due in part to the Federal Patient Self-Determination Act, the patient has a right to refuse resuscitative efforts. An advance directive, which is instructions written in advance against resuscitation, signed by the patient, is a legally recognized document. Okay? You have several types of advance directives. You have DNRs, which is a do not resuscitate order. You have living wills. You have healthcare durable power of attorney or a healthcare proxy. And then you have physician's order for life-sustaining treatment. Okay? The most common things you're going to see around here are these DNR orders. All right? Occasionally, you'll see this healthcare durable power of attorney or a healthcare proxy. That only comes into effect if the patient is not able to make decisions for themselves. This person that they designate as their healthcare power of attorney will then make the decisions for them. Okay? All right. This is what a DNR order looks like. This is from Ohio. Okay? All right. The ones here are going to look completely different. All right. All right, issues and advance directives. Some of the issues you may encounter at the scene regarding a DNR are questions about the validity of the document, interpretation of what care should or should not be provided, conflict between the DNR and the physician orders, and the wishes of a family member. To protect yourself, the best manner to proceed is to, 1, consider immediate treatment. So that the issue cannot be resolved, you will not be held negligent for not providing care or delaying treatment. 2, you need to contact medical direction for instructions on how to proceed. And 3, continue treatment until the problem has been resolved. All right. You must respect the decision of patients who refuse care, but must advise them of the potential risk of their decision and let them know that they can call EMS again if needed. You will be in a much better position if you are providing treatment rather than withholding treatment when faced with questions about whether to provide care. In the absence of a valid DNR order or a physician's written instructions, you are obligated to begin full resuscitation or needed treatment immediately. All right. Patient's refusal of treatment involves legal, ethical, and moral decisions. You must assess the patient's ability to understand treatment options and their ability to respond adequately in making informed decisions regarding consent or refusal of treatment. This is referred to as the patient having the capacity to make a decision. You must make sure you've done everything you can to persuade the patient to accept treatment and take the steps to protect yourself from liability. Okay? Capacity. If an adult refuses care, they must have the mental capacity to do so. An adult with the mental capacity to do so is one who is lucid and capable of understanding various treatment options, and they're able to make rational and an informed decision. The term capacity is often used interchangeably with competence. However, capacity is determined by a medical authority, whereas competence is a legal definition and determined by a court. Okay, a patient is determined to lack the capacity to make a rational decision is referred to as de facto incompetent. This means that the patient is in fact incompetent but not determined to be so through a legal process. Right, under the law, to refuse treatment or transport, a patient must be informed of and fully understand the treatment and all potential risks and consequences of refusal, up to and including the possibility of death if that is a potential risk. Have the patient explain to you what those potential consequences are if the treatment is refused. If the patient does not understand the consequences, then they would be deemed to lack the capacity to make a rational decision, or simply referred to as incompetent, and treated under implied consent. Once this has been accomplished, you must attempt to get the patient to sign an official release from liability form. All right, complete and accurate documentation is a key factor in protecting yourself from liability for malpractice in the form of negligence or abandonment when a patient refuses treatment. All right. Always keep complete and accurate documentation. All right. Try to enlist bystanders, the other responders, to help you talk the patient into going. All right. Your case study. I can understand how you might feel like people are in your business, Caitlin says. We're here to help, but before we decide what to do, I need to ask you a few questions. First of all, what is your name? Mike Blevins. Well, Mr. Blevins, do you know where you are right now? All right. This is Caitlin beginning the process of determining the patient's decision-making capabilities. All right. What are some of the other questions that Caitlin could ask to help her decide whether the patient has the capacity to make important decisions, such as consenting to or refusing medical care? All right. The guy knows who he is. Does he know where he's located, what city he's in, what town he's in, what year it is, who the president is? Things like that most people would know. Okay. All right. Negligence. If you breach your legal duty, you create a liability. There are two types of liability, criminal and civil. In a criminal liability case, the government, on behalf of the public, brings legal action against you. This may result in a fine or even incarceration. In a civil action, an individual, known as the plaintiff, files a lawsuit against an individual EMT, the EMS agency or company, and other indirectly involved in the care of the patient, such as your supervisor or your medical director. These latter individuals are known as defendants. All right, you can guarantee that if you get sued, your EMS agency is going to get sued, and your medical director is also going to get sued. All right. Blah, blah, blah. The two types of liability that we talked about are criminal and civil. In criminal cases, a law is broken and the government brings legal action. In civil cases, a person sues for damages. To prove negligence, right, the plaintiff or the complaining party must prove that the EMT had a duty to act, that the EMT breached that duty, the patient was injured, and the breach of duty caused injuries. They must prove all four of those things to be rewarded any kind of damages, okay? You need to know those four things. You had a duty to act, you breached the duty, the patient suffered harm or injury, and the injury was a result from that breach of duty, okay? There are two common legal principles often associated with negligence claims against EMS. All right, the first one, I'm not even going to try to butcher this, but it means the thing speaks for itself. This concept is used in cases where a caregiver's inappropriate actions are obviously the cause of the patient's harm. The concept of negligence per se means that an act is considered to be negligent simply because it is in violation of a statute or regulation, such as written EMS protocols or an approved scope of practice. All right, you have intentional torts. You have abandonment, assault, battery, false imprisonment, and defamation or slander and libel. Okay? The difference between intentional and negligence is that negligence is a failure to meet the standard of care, whereas intentional tort is knowingly committed. All right? So, you must always transfer patient care to a profession or a professional of equal or better training to avoid charges of abandonment. Okay? I can't go to a nursing home as a paramedic and leave my patient in the care of an LPN or a CNA. Okay? They are not my equal or better. All right? Just like you cannot go to a nursing home and leave the patient with the CNA. All right? They're not your equal or better. All right. Confidentiality. Information obtained while getting a patient history, performing a physical assessment, and treating the patient must be kept strictly confidential. The deliberate invasion of a patient's privacy by an EMT may lead to loss of certification or licensure and other legal actions. Okay? By law, you can release information if it is needed in order to continue medical care. Mandatory reporting laws apply. If there's been elder abuse, child abuse, domestic violence, things like that, crime, all right? You are part of a police investigation or a criminal investigation. Third-party billing requires the information, or you are subpoenaed by a court of law. HIPAA. This is the Healthcare Insurance Portability and Accountability Act. All right. The Healthcare Insurance Portability and Accountability Act of 1996 is a federal law that protects the privacy of patient health care information and gives the patient control over how the information is distributed and used. HIPAA requires strict adherence to policies and procedures regarding record keeping, storage, access, release, and discussion of patient medical records. EMS systems are required by federal law to have specific policies and procedures in place regarding confidentiality and privacy issues related to patient care records and information. All right. HIPAA is a federal law that protects the patient's privacy of healthcare information. All right, let's talk about COBRA and EMTALA. COBRA is the Consolidated Omnibus Budget Reconciliation Act, also known as COBRA. The other one we're going to talk about is EMTALA, Emergency Medical Treatment and Active Labor Act. All right, these are two federal regulations that ensure the public's access to emergency health care regardless of their ability to pay. COBRA and EMTALA are federal laws that guarantee people will get health care, okay? In an emergency transport, do not make a decision to transport to a specific facility based on the patient's ability to pay. Also, do not bypass a facility that is able to treat the patient unless directed to do so by medical direction or protocol. If a bypass occurs, you must thoroughly document the reason for bypassing the closer facility, okay? All right. You need to, when you're transferring from one facility to the next, obtain written certification from the transferring physician. Okay. You need to know who the transferring physician is. You need to know who the receiving physician is. All right. You need to know that you can provide the level of care needed during transport. Okay. If this patient is going to stop breathing on you, and they're going to need to be intubated, they're going to need to receive medications en route, that is beyond your scope of practice, okay? So, you do not need to take that transfer, all right? Know where you're going and take the quickest route possible. All right, organ donation. A potential organ donor should be treated no differently than any other patient regarding emergency care. The individual is a patient first and an organ donor second. All right. Just because you have that little thing on your driver's license, that is not a legal binding document. Okay. That gives your intent to donate organs. All right. Your family makes that final decision, so they need to know your wants, wishes. Also, we need to look for bracelets, necklaces, or cards that identify medical conditions, all right? Medical alert tags. Also, some people are getting these tattoos, all right? Can be overlooked as body art. How to recognize death in the field, all right? There are obvious signs of death that preclude resuscitation attempts, which includes decapitation, where your head is completely removed from your body, all right? Decomposition, where your skin and your organs are breaking down. All right, you will know it when you smell it. All right, you have rigor mortis. This is where your muscles become very, very rigid. All right, you're not going to be able to move the extremities. You'll see it in the neck. You'll see it in the hands, the fingers, the arms, the legs. All right, and what we call dependent lividity. And this is where the blood pools. The blood pools because of gravity. The heart is not pumping that blood forward, so it just stops. All right. You must recognize cause that require contacting legal authorities, including the medical examiner or coroner, police, and authorities who investigate abuse. All right. One thing about this, there's an exception for hypothermia patients. All right. If I respond to a drowning in December and the river is ice cold, okay, the rule for EMS is you're not dead until you're warm and dead. All right. So we will work that until we get your body temperature up to what it normally is. All right. Then we can call it. All right. For patients with advanced directives, this means absence of a pulse and breathing. They are completely unresponsive to any stimuli. There's no eye movement or pupillary response. They do not have a blood pressure, and there are no reflexes. Okay? You're not going to see the decapitation. You're not going to see the decomposition. You're not going to see the rigor mortis, and you're not going to see the dependent lividity with these. These are the ones that have just passed. Okay? All right. All right. Cases involving investigation by the coroner or the medical examiner. These are homicides, suicides, any kind of violent death, crash-related death, unusual scene characteristics, SIDS, infants. SIDS is sudden infant death syndrome, and anything that is DOA or dead on arrival in most locations. All right. It's important to understand your local protocols related to death in the field situations. It is better to err to benefit the patient and begin resuscitation if you have any doubt. Also, be sure you understand the situation in which the medical examiner or coroner must be called to investigate a field death. Crime scenes. Your first concern upon approaching a crime scene should be your own safety. Okay? Dispatch should also notify you that this is a potential crime scene. Recognizing a possible crime scene requires a high index of suspicion. As a general guideline, a potential crime scene is any scene that requires police support, including a potential or actual suicide, homicide, drug overdose, domestic dispute, rape, abuse, hit-and-run accidents, riot, robbery, gunfire, or potential for dangerous weapons. When responding to a crime scene, wait until the police declare that the scene is safe. All right, even when they declare that the scene is safe, it can still be potentially dangerous. Always watch your back, watch your partner's back, okay? Do not get hemmed up somewhere where you cannot get out of a situation, all right? Once the scene is secure, your priority is emergency care of the patient, all right? All right, avoid disturbing potential evidence. Take one way in and one way out. Do not touch anything that you don't have to touch, okay? If you do touch something, you need to let a police officer know. If you move something, you need to let a police officer know. Do not use a house phone at a crime scene. Do not use a cell phone, the victim's cell phone at a crime scene, okay? You're going to be disturbing evidence, all right? In the absence of police permission, move the patient only if they are in danger or must be moved for you to provide care. Observe and document carefully. Do not cut through bullet holes or stab wounds in clothing, okay? Those can also be used in crime scene analysis. Avoid disturbing potential evidence, all right? Do not cut through a rope knot or a tie. Do not cover the patient with a sheet, all right? If you are responding to a rape, do not let the patient wash or allow the patient to wash. All right, ask them not to change clothes. Don't let them use the bathroom. Don't let them eat or drink anything. Brush their teeth. Okay? All right. You may be required to report certain conditions to law enforcement, social work, at the hospital, or both. Other situations than those listed that the EMT may be required to report, including suspected infectious disease exposure, use of patient restraints to treat or transport against their will, cases in which a patient appears to lack mental capacity to make decisions, intoxication, attempted suicide, and dog bites. Baby Safe Haven. In the 1990s, an alarming number of infants abandonments occurred, resulting in many infant deaths. At that time, a parent was criminally prosecuted for negligence or abandonment if an infant was left unattended with the intent of relinquishing custody. As a result of the surge in abandonments, many states now have safe haven laws designed to allow parents to relinquish custody of an unharmed infant to a proper authority. Okay, your EMS station, your fire station, your police station, churches, hospitals, libraries, courthouses, all of these places are safe havens. Okay, a baby can be left there, nothing. No, nothing. All right, so here's your summary. All right, please keep in mind that you can be charged with abandonment, which is terminating care without the patient's agreement and without transferring care to another provider. You can also be charged with battery if you attempt to take a patient that does not want to go with you and they are mentally capable of making an informed decision. All right, if you put your hands on them, you can be charged with battery. You can be charged with negligence, in which there was no intent to cause harm, but you caused harm. All right? All right, that concludes, I believe that was chapter 3. Maybe.